Okay, let's proceed. So we talk about the 5 elements of misrepresentation. So the third one said that this person must have relied on the statement. The defendant must have relied on the statement. The next, he must have bought the shares. He must have bought the shares. And then lastly, the statement was false. The statement was false. Because for you to avoid liability for misrepresentation, that statement must actually have been false. The statement was false. Okay? Then part 3. Now, part 3 is a very important one. That's what I want to see. Now, advise Saulo, Baraka, Sadiki on possible action against the company. I want you to tell me whether any of these people have got a liability, they have got a right against the company for the misrepresentation in the prospectus or not. Because we are told that, let's go to the question again. The company is about to make a new issue of 800,000 shares of 20 shillings each. The prospectus has stated that the seeds produced by the company yield 20 bags per acre, even on arid land. That's what the prospectus said. And that the company was the only one with such kind of seeds. There was also a publication in the local newspaper about the shares. No. But then, that item number 4 now, the other additional information, that an actual analysis of the seeds was done, and it was discovered that the seeds were not as productive, only yielding 5 bags per acre, and could only thrive in wet land. The shares of Mbegu Zuri Limited thereafter dropped in value to 5 shillings per share. No. So with reference to the above scenario, now advise Saulo. Now let's look at the idea, the position of Saulo. Saulo Mpoa did not read the prospectus, but applied for the company's shares and was allocated 4,000 shares at 40 shillings per share. What do you think? Can Saulo have a remedy against the company or not? Somebody, what's the last part of our question that are case questions requiring application? Does this guy have a remedy against the company, and why? Saulo, looking at each person. Saulo. Eli says, I think no. No, it's not you. I think you want to think it out. Eli says no. Reason? What could be the reason, Eli? Somebody else, no, yes, that's a small reason. Just a short one, brief one. Kila mtu ajaribu, please. We see Sylvester, then Abdi there. Jaribu tuangalie reason. Assume we go from mtihani. Does not read the prospectus. Abdi. Okay, what Abdi has said? Abdi says no because he has not read the prospectus. Now that is okay. Eddie had failed to explain, but now the explanation is with the Abdi that no, because he has not read the prospectus. Remember what we said, that whenever a prospectus contains a misleading statement, now Eli, look at what you have said, that the reason is because he fails to find the information about the prospectus before buying the shares. Now, unaona umeenda story mrefu sana Eli. he fails to find the information about the, why don't you just say because he did not read the prospectus? You know, that's shorter, like you put it the way Abdi has put it, just go straight to the point, that he has no remedy, the reason being that he has not read the prospectus, isn't it? Yeah, straightforward. He has not read the prospectus. When you say he fails to find the information about the prospectus before buying the shares, no, we made a stream ref. Let's go straight to the point. No, because he has not read the prospectus. Remember what we said, that for a person to avoid liability on grounds of a misrepresentation in the prospectus, he has to show two things. First, he was original allottee, that is, he bought the shares directly from the company, and also he read the prospectus. Those two conditions are necessary for the allottee to be able to avoid liability and even return those shares to the company. That he read the prospectus, and then after reading the prospectus, he was given the shares directly by the company. That is, he was an original allottee. He bought the shares directly from the company, but not in the open market. So about Saulo here, we are told he did not read the prospectus, but of course he was given the shares by the company directly. So he met one condition, but failed in the other. So he cannot sue the company. So we say Saulo has no remedy. Saulo had no remedy, has no remedy against the company, because in buying the shares from the company, he did not read the prospectus. He did not read the prospectus, and therefore he was not influenced. And therefore he was not influenced by the misrepresentation in the prospectus, and therefore was not influenced by the misrepresentation in the prospectus. Next, what about Baraka? Baraka, we are told, read the prospectus and was not allocated the company's shares. She bought 6,000 shares of the company at the Securities Exchange at 50 shillings per share. How about that one? What do you think? Another attempt, jaribu tufanye pamoja. I don't want to give you the answers. Nataka nyinyi wenyewe mnipatie. Mimi natoa kama umeiva. Sylvester, what do you think? What ideas?
Credit notes issued. So credit notes are issued by the business when actually they say that those are credit notes issued.
Yeah, chap, taking long. Sadiki, not the media is a company because it is the company. Yes, Eli says that he has no remedy against the company because he did not buy shares directly from the company. That's very good. Yeah, now you must style up. Eh? Yeah, that is to the point. Yeah, Sadiki, not Baraka, read the prospectus. Yes, it is okay. But then, unfortunately, he did not buy the shares directly from the company. So he did not contract with the company. So you cannot have a remedy against a person who did not contract with, isn't it? So this guy was supposed to, apart from reading the prospectus, he was supposed to have been allocated the shares directly. Okay? That is okay. So we say Baraka has no remedy. Okay, say Baraka, although he read Baraka, he read the prospectus, Baraka, though he read the prospectus, has no remedy against the company. Has no remedy against the company because he did not buy the shares, because he did not buy the shares directly from the company, because he did not buy the shares directly from the company. But he bought them from the Securities Exchange. That is the open market, okay? Sadiki Mulwa, this guy read the publication in the local newspaper about the company's shares and bought 10,000 shares at the Securities Exchange. What about Sadiki? Sadiki, akona remedy ya mapana. Sadiki. The guy read this publication in the newspaper about the company's shares, but again bought the shares at the Securities Exchange. What do you think, Sadiki Mulwa? What is his position? Sylvester, unaonaje? So you are quiet. Unashikanisha ama inapita huku na huku? What do you think about this Sadiki? Sadiki Mulwa. Okay. Abdi anasema no, he bought the shares from the Securities Exchange. Eli says it did not meet the two conditions, hence no remedy. Okay, yeah, that is okay. This guy did not read the prospectus. Because that publication is not a prospectus. At the same time, he bought the shares from the Securities Exchange. So again, no remedy. Okay? So if Sadiki has no remedy, as he neither read the prospectus, nor bought shares from the company, directly from the company. Now you can see, it means that in all these cases, the respective persons have no remedies against the company. But unfortunately, in the exam scenario, you know what will happen? You go to the exam, ukiandika unaangalia no remedy, sema hapana. The devil visits you. Then unasema hapana, one must be having a remedy. You cannot get all of you do not have a remedy. When you start thinking like that, it's because you do not understand the concept. Because we said that whenever a prospectus contains a misleading statement, then you say that they are original allottee of shares who relied on the prospectus, but not a buyer in the open market, has a right remedies against the company, or has a remedies against those people who misled him. the original allottee of shares, who read the prospectus, who relied on the prospectus in buying the shares from the company directly, is one who will be entitled to the remedy. So you must have read the prospectus, and secondly, bought the shares directly from the company. Because if you bought shares from outside, from the open market, it means you did not contract with the company. Okay, the company only owes a duty to the persons to whom it gave shares. Okay. Okay. Question number 6. In the context of company accounts, audit, and inspection, highlight 6 individuals to whom the court might provide a copy of the inspector's reports. I think we did a similar one. That's right. The court itself, or the court, oh no, or the court is on to provide now. Okay, the registrar. Let's talk about the registrar. Excluding the court, because the court has a copy already, so it has to give to other people now. The registrar, next, the attorney general, then the applicant, the members who applied for investigation, next, the company itself, the next, any member of the company, any other member of the company, upon payment of a fee, the next, a receiver, in case of a company, that is under receivership, okay, receivership or administration. So if there was investigation, then that receiver or administrator will be entitled to a copy of the report. Okay. Then part B, in relation to debt capital. 1, highlight 6 types of charges which require registration as outlined in the Companies Act. Registrable charges. Remember, we're talking about registrable charges here. We're talking about property. We're talking about that property which, if used as security for a loan, should be notified to the registrar. Because when you're using your assets as security for a loan, it means you have charged your asset. So the Companies Act provides that whenever you use certain specified assets as security for a loan, then you must inform the registrar. So it means you have to register that with the registrar. What are some of these forms of property which, when used as security for loans, should be registered with the registrar? Number 1, a floating charge on the undertaking, on the property or undertaking of the company. A floating charge on the property or undertaking of the company. Next, a charge on any immovable property, of the company, a charge on any immovable property of the company, wherever situated, a charge on any immovable property of the company, wherever situated. Next, a charge on book debts of the company, of the company. Remember, book debts are like debtors, okay? A charge on calls made but not paid. A charge on calls made but not paid. Next. A charge on uncalled capital. A charge on uncalled capital. Next, a charge on a ship, not to go, no, ship, mainly a charge on a ship or any share in the ship, or any share in the ship. Next, a charge on the goodwill. The charge on the goodwill, patents, trademarks, or copyrights of the company, Abdi, number 9 ni gani? Sema number 3 ni gani? I'm dictating them off right now. Let me see. Okay. Book debts. Is it a book debts or what? Anasema to repeat number 3. Who remembers that number 3? Is it a charge on book debts? Well, I think the first one was a floating charge on the undertaking with the property or undertaking of the company. I think the second one was floating a charge on any immovable property of the company. Yeah, number 3 was book debt. Yeah, I think I was right. A charge on book debts of the company. Then I said book debts include debtors. Okay. Then part 2. Explain 4 disadvantages of a floating charge to a debenture holder. Disadvantages of a floating charge. Now, we know something about floating charges. That a floating charge, we said it was a charge that was created on the general assets of the company. So that when the company is creating this floating charge, it does not specify a particular asset that's given to you as security. So that the company just tells you that if we don't pay you, you can sell any of the assets. So that is different from a fixed charge on which the company identifies a particular property to be forfeited in case of default. So what are the disadvantages of floating charges? Number 1, the company is free. The company is free to sell the assets, and the value of the remaining assets, at the time the debenture holders, wish to take action, may be lower than the value of the loan. Yeah, because the company is free to sell the assets. So that by the time it defaults and you want to take action, you find that the value of the remaining assets now will be less than the value of the loan. So you don't get the full amount. But of course, we say something that if you want to ensure that the company does not sell the assets below the nominal value of the loan, what are you supposed to do as floating charge debenture holders to prevent the value of the remaining assets, or to prevent the company from selling the asset to a value that will be less than the nominal value of the loan? What are you supposed to do to safeguard your interests and as floating charge debenture holders? What are you supposed to do? Yeah, execute. We say execute a debenture trust deed. Isn't it? Appoint a trustee. Yes, the debenture holder is supposed to appoint a trustee, because we know that from the terms of the trust, from the terms of the trust deed, the company is prohibited from selling the assets or even creating a subsequent fixed charge over the same asset that was secured as security. Next, the company can create a fixed charge. The company can create a fixed charge on the same assets. On the same assets, and the charge shall have priority. And the charge shall have priority over the floating charge. And the charge shall have priority over the floating charge. So the same way the company is free to sell the assets, again it's free to create a fixed charge over the same assets secured by floating charge, but of course unless a trustee is appointed. Next, notice of a floating charge. Notice of a floating charge does not stop subsequent fixed charges. Notice of a floating charge does not stop subsequent fixed charges. The next, all floating charges created 6 months before liquidation. Created 6 months before liquidation are void. If at the time the charge was created, are void. If at the time the charge was created, the company was experiencing financial difficulties. The company was experiencing financial difficulties. Okay. Then another disadvantage is that a landlord can distrain. To distrain is like to levy distress, to attach the property. A landlord can distrain for rent before the appointment of a receiver. A landlord can distrain for rent before the appointment of a receiver, thereby reducing the value of the assets available. Thereby reducing the value of the assets available to floating charge debenture holders. Okay. Then question number 7. With reference to the case of National Dwelling Society versus Sites, enumerate 5 duties and 5 powers of the chairman of a general meeting. 5 duties and 5 powers of a chairman of a general meeting. Now, we have a difference between powers and duties. There's a difference between powers and duties. Duties are things the chair must do by virtue of being the chairman. The obligations. And if you fail to do that, what you're supposed to do can even be removed from chairmanship of the meeting. But powers are discretionary. Powers are discretionary. It's not a must to exercise a power. So for powers, it's not a must to exercise the powers. They are discretionary in nature. So what are the duties of the chairman of the general meeting? It's a meeting generally. Because he has told, enumerate 5 duties and powers of a chairman of a general meeting. 5 powers and 5 duties. So start off with the duties. What are the duties of the chair? Duties of the chair. What do you think? The first one, of course, is to ensure that the meeting has been properly convened. To ensure that the meeting has been properly convened. In line with the Act and the articles of the company. In line with the Act and the articles of the company. In line with the Act or the articles of the company. Okay. Another. Any other? Powers, the duties of the chair. Okay, we can talk of to preserve order. Preserve order. To preserve order of the meeting. Next. To ensure that the meeting is properly constituted. The first one was convened, properly constituted, and there is quorum. And there is quorum. And there is quorum. Next. To ensure that the proceedings of the meeting, are conducted in accordance with the rules, governing the meeting, Next, to ensure that the business is conducted, in the order shown in the agenda, And lastly, you can add to conduct voting, and to declare the results, to conduct voting and to declare the results. Then powers are discretionary. So the first one, to decide on points of order. As they arise. Now, a point of order, it's a contentious issue at the meeting, which must be resolved before the meeting can peacefully proceed. Okay. Next, to use the casting votes. In good faith. To use the casting vote in good faith and in the best interest. Of the company. Remember, the casting vote is a vote cast by the chair where there is a tie in the voting, like 20 against 20. And the chair may be required to vote to get the winner. And when he's using that, we say he should do so in good faith and in the best interest of the company, not as a way of settling scores with the enemies. Now, the enemy was and then you do that against the enemy. No. Next, to order remand for disorderly persons. Next, to order the removal of any person who has no right. To be present at the meeting. And also, lastly, to adjourn the meeting. That is to adjourn the meeting, e.g., where there's no quorum. To adjourn the meeting, e.g., where there is no quorum. Okay. Then second last there, Shauri Moyo, Part B, Shauri Moyo Limited is a non-public listed company. The company has 3 directors, BD, Mapesa, and Shinda, who are also the only shareholders. The company requires additional finance and is proposing to issue a block of ordinary shares to Zindua. The shares have a nominal value of 200 shillings each, and Zindua has agreed to pay 220 shillings per share. However, it's agreed that Zindua will only partly pay for the shares at a rate of 20 shillings per share. Advise BD, Mapesa, and Shinda on the legal issue relating to the proposed issue of shares to Zindua and payments thereon. Okay. Now, then part C, explain the benefits of including a negative pledge clause in a floating charge to the shareholder. Now, I want to give you time as we break, just 10 minutes break, and then you tell me what you come up with. I want to see how far you have gone. It's a tricky one, but I want to see whether you're able to pick out something. Those 2 questions at B and C. Just 10 minutes break, then we finish up with that. Okay, what do you think about this question? I think you've given it a thought. That Shauri Moyo Limited is an unlisted public company. The company has 3 directors, BD, Mapesa, and Shinda, who are also the only shareholders. The company requires additional finance and is proposing to issue a block of ordinary shares to Zindua. Of course, we know directors have got the power to issue their unissued capital. Then the shares have a nominal value of 200 shillings each. And Zindua agreed to pay 220 shillings per share, meaning the 20 shillings will be the premium. However, it has agreed that Zindua will only partly pay for the shares at the rate of 20 shillings per share. The nominal value is 200, atalipa only 20 shillings per share. What do you think? Any idea? So advise Mapesa and Shinda on the legal issues relating to the proposed issue of shares to Zindua and payments thereon. For the first principle is that directors have the power to issue the unissued shares of the company. Directors have the power to issue the unissued shares of the company. Next. Before allotment, the company must have received at least 5% of the shares in cash, at least 5% of the shares in cash, and the whole of the application money, and the whole of the premium. 5% of the shares in cash as application money, the company must have received at least 5% of the nominal value in cash as application money, and the whole of the premium. Okay. Now, when you look at what we are receiving here, 5% of the application, 5% of the nominal value, how much is that? 5% of 200, 5% of 200. Ndio watu wa hesabu. 500 times 200. It's 10 shillings, isn't it? 10 shillings. 5% of 200 is 10 shillings. Lakini huyo amelipa ngapi? You only partly pay for the shares at rate of 20%. Then the premium is 20 shillings. Sasa inamaanisha there's a problem there, isn't it? There's a problem because the premium is 20 shillings. Because the nominal value is 200, the doors are going to pay at 220, so 20 is premium. So the premium has not been paid. If he's paying 20 shillings, then we can assume that now he has paid the application money over at least 20 shillings. But the premium has not been paid, isn't it? So is it a valid allotment? So so we say in this case, the allotment is not valid. The allotment is not valid as the premium has not been paid. As the premium has not been paid. Okay. Then lastly, part C, explain the benefits of including a negative pledge clause in a floating charge to the holder. Benefits of the negative pledge clause. Now, negative pledge clause. What is a negative pledge clause? What is a negative pledge clause? Remember, a pledge is a promise. So a negative pledge is an undertaking by the company to the floating charge debenture holders that it will not create a subsequent fixed charge on the same assets secured by that negative pledge clause, secured by the floating charge debenture holders. So that we are telling the debenture holders of the company that we shall not create any subsequent fixed charge on the same assets that we have given to you as floating charge. So the question is, explain the benefits of including a negative pledge clause in a floating charge to the holder. So the first one, because it prevents the company from creating a subsequent fixed charge, on the assets secured by a floating charge, and of course, it provides a security for the floating charge debenture holders. Okay. Now, that is it. I can see we have revised all those questions from September 2015 up to 2020. I think, up to November 2020. All those papers, we revised them. And one thing about the areas we have revised is that we've seen some questions being repeated. And that tells you that even in our final exam, we'd expect some questions to be repeated. And please, I don't expect that we'll have questions that will be repeated, and then somebody in this class, bado anaanguka. Sasa, then why would you be attending this revision if questions you've done in class for which you are revising through the exam zinarudiwa na bado unaanguka? That would be a very bad thing. So as you revise now, make sure, apart from reading your notes, also you study those questions and answers very well, so that there should be no question that will be set from what you've done. Please make sure that everything is okay. Okay. Now, areas I expect you to cover so much. Make sure unaelewa hiyo syllabus yetu vizuri. Now, the 5 rules in company law. I want you to concentrate on the 4 rules, leave out 1. I want you to concentrate on the rules in force versus Harpottle, Royal British Bank, force versus Harpottle. Then we have Royal British Bank versus Taquan, Trevor versus Whitworth, and then Sharp versus Dow's. Those rules, make sure you understand them very well. Their purpose and the exceptions, okay? Then, when you look at share capital, please, that aspect concerning the prospectus, the misleading prospectus, because you get to know the contents of the prospectus, methods of raising capital, but then now the remedies available for a misleading prospectus. A very important remedy like rescission. What the misled investor has to prove for him to be entitled to rescind the contract based on a misrepresentation in the prospectus. And also, you have to know when the right of rescission is lost. They just covered in the notes clearly. Also, you have to know the persons that will be liable for the listing particulars in the prospectus. And then the defenses available to a director who has been sued for a misrepresentation in the prospectus. Okay? Then look at the rules relating to allotment of shares. For the rules that relate to allotment of shares, we have statutory rules and general rules. The general rules are those rules relating to the law of contracts, offered and accepted the law of contract, and then statutory given by the statute. Now, the statutory rules are two categories. One, where no offer is made to the public, so that where no offer is made to the public, we know that the company shall not allot shares unless it has filed a copy in lieu of prospectus with the registrar 3 days before allotment. Then when an offer is made to the public, of course, a prospectus must be filed with the registrar. The company must have received the minimum subscription before allotment. It shall not proceed to allot shares unless it has received at least 5% of the nominal value of the shares. Anything else? It shall not proceed to allot shares until the beginning of the 3rd day from the time when the prospectus was issued. Okay. Now, then I also want you to understand the reduction of capital. The reduction of capital, right from the methods of reducing capital. We talked about 4 methods by which the capital of the company can be reduced. Then the procedure of reduction of capital. The procedure of reduction of capital. Then maintenance of capital, raising and maintenance of capital. The rules relating to maintenance, raising and maintenance of capital. Then from that, we also look at debt capital. Remember, shares, share capital, and then debt capital. That is debentures. Those are very important topics in company law. Then which other area? Of course, this is another area that has not been examined, and I need you to look at it very keenly. That small part on administration, stock receivership of companies. Remember, this aspect was introduced in 2018, and since then, I think it hasn't been set. Please make sure you understand the aspects concerning the receivership and administration of companies. Of course, we did a question on the difference between receivership and liquidation, but also just understanding other areas like objectives of administration of receivership, appointment of a receiver, the powers of a receiver, the effect of the order of receivership, or administration order, like that. Make sure you understand those aspects very well. Any other bit? Of course, it's very important to understand the introductory bit of company law. Please. Introductory bit, that first topic that includes the classification of companies. It would be very wrong to get somebody who does not understand classification of companies. We should have many questions on that. And then the foreign companies, it's a very popular, it's a small bit but very popular. Continue reading more and more about foreign companies in particular. Okay. Anything else? Yes, look at. Now, just some question here, some small, this is a few questions here. Question number one, just writing a questions. Question number one, discuss the rules which govern the following. Discuss the rules which govern the following. A, voting by proxy. Voting by proxy. Then B, revocation of the authority of a proxy. Revocation of the authority of a proxy. Remember your meetings. So how can we answer that? Voting by proxy, rules related to voting by proxy. So we say a proxy has a right to vote, on behalf of a member. A proxy has a right to vote on behalf of a member. Next, he can vote on either a show of hands. He can vote on a show of hands or on poll. On poll means based on the strength of shareholding. Another rule. A proxy may either be general or special. A proxy may either be general, special, or general or special. General or special. So what is the difference in that? We say, of course, we talked about that. A general proxy votes at his discretion. A general proxy votes at his discretion, while a special proxy votes as directed. By the appointing authority. Okay. Then revocation of the authority. Revocation. How do you revoke the authority? What are the circumstances under which the authority of the proxy may be revoked? So the authority of the proxy may be revoked in the following circumstances. One, when the member personally attends the meeting. When the member personally attends the meeting. Next, when the member revokes the authority of the proxy. When the member revokes the authority of the proxy by written notice to the company. Next, when the company receives notice, of the member's death, or insanity. Next, when the proxy form was delivered to the company. When the proxy form was delivered to the company less than 48 hours. Before the meeting, before the date of the meeting. Any other question we'll talk of? Now, another question. Explain the conditions to be fulfilled. Before a company can pay an underwriting commission. Conditions to be fulfilled before a company can pay an underwriting commission. Remember, the underwriting commission is a commission paid to a person who agrees to take up any shares of the company that would not have been taken up by the public. You pay this person or this should have an underwriting commission. So what are the conditions to be fulfilled before the company can do that? Number one, the payment must be authorized by the articles. The payment must be authorized by the articles. Another one, the rate of commission must not exceed. The rate of commission must not exceed 10%. Must not exceed 10% of the value of the nominal value of the price, 10% of the price at which 10% of the price at which the shares are being issued. The next, the amount and rate of commission. The amount and rate of commission must be disclosed. Must be disclosed in the prospectus. Must be disclosed in the prospectus. If shares are issued to the public, if shares are issued to the public, and if not, then in the statement in lieu of prospectus. The statement in lieu of prospectus. Okay. Then another question. Explain the purposes. Explain the purposes for which shares may be issued. Explain the purposes for which shares may be issued other than for raising capital. Other than for raising capital. Now, let me give you 2 minutes to think about it. Because ordinarily, we know shares are only supposed to be issued for purposes of raising capital. But what are the exceptional cases when shares can be issued and the objective is not to raise capital? Please keep it real. When shares can be issued, but the objective is not to raise capital. Fikiria haraka haraka. Now, let's see. Earlier, what I was saying, rules governing proxy about joining or demanding a poll. When the proxy is demanding for a poll, that's not voting. No, it's not voting. But the question is about voting by proxy. Okay? And then Abdi say when the company don't pay dividends, no. Now, rights issue. Rights issue, definitely that one is about raising capital. The objective of rights is to raise capital. But first, by issuing to the existing shareholders. So let's summarize that. The reasons why a company may issue shares, but the objective is not to raise capital. Even if it can end up receiving capital, but the objective is not to raise capital. The first one, in case of a bonus issue, in case of a bonus issue, the second one, in case of a bonus issue, the second one will be, tell me. As a defense against a hostile takeover, Next, in case of management shares issued to the promoters, in case of management shares issued to promoters. No. Those are ways when you can issue shares, but the objective is not to raise capital. Sawa. Now, our time is up. Now, what I expect of you next week, now exam is next week. You know, when the exam was pushed ahead, we imagined the next week will not come. It is here with us. Oh, very good. Somebody earlier has talked about the employee share scheme. Yes, shares issued under an employee share scheme. Please, that is okay. Purpose not to raise capital. Yes, very good, Eli. Employee share schemes. Shares issued in case of employee share schemes. Because the purpose for those shares is to motivate employees, isn't it? And make them part owners of the company. Very good. Now, we already talked about what I expect of you in the exam. Please read your notes well. Understand all the questions you've done in class. Okay? And the example I said, the moment you get your paper, please don't start writing kimbia. I said that if you choose your 5 questions, before you even start answering them on the question, on the answer booklet, please, just on that question paper, write whichever answer question 1A, write the answers for question 1A, question 1B, C. Question 3 that you've chosen, again like that. Take even if it means 15 minutes before you start writing. Write answers. Because I said, if you start writing without planning like that, the points that you knew at the beginning of the question, the exam, they may disappear even before you go to that question. So first of all, offload everything on the question paper. Everything that you remember at the time the exam is starting, offload everything on the question paper. Then once you have all the answers, whatever you had forgotten, itakuja baadaye. Then try your best also that you don't leave blank spaces. If you have decided to answer question 1, for example, if you decide to answer question 1, make sure you answer all parts of question 1. Hata kama kuna moja uelewi vizuri, try to guess. I'm sure there's something right you can guess. You see it for blank. These questions are set from your syllabus. And if you are keen enough, you're able to get an answer. You've seen from what you've done from September 2015 up to the end. There's no question you've not answered. It means we are able to do something about it. Please, how many marks do you get from a blank? We say you don't get anything. But if you guess, you never know. You can get something out of it. Okay? That we said the other time. And most importantly, I'll still emphasize the need for you to pray to your God. Even if you don't know how to pray, at least for exam purposes, make a short, faithful prayer. A short, faithful prayer to God. For God to guide you. For God to give you the wisdom. to be able to remember things that you had forgotten, so that you remember when you're sitting in the exam room. Okay? So it's very important. Also pray for your exam, for the examiners who will mark your paper, so that they exercise discretional marks, the power to give discretional marks in your favor. Please, passing is a very fine, there's a very fine difference, very small difference between passing and failing sometimes. Those discretional marks. Examiner anaangalia kitu haiko kwa skill, lakini it's not right, it's not wrong. If there is any discretion in your favor, wacha nimpe tu. But if the devil is with you, anasema no way, nisimpe na angusha. It is not done wrong. No, when you have a discretion, you can give or not give. Either way, you are right. You see? So also pray for your examiner to ensure that hata mark paper yako ana mark vizuri. Otherwise, thank you so much for your time, and I believe you'll be good ambassadors. You have all that it takes. And please, as you go to the exam, cite yourself, I must pass. Come rain, come sunshine, I must pass company law and any other paper that you are taking. Sawa sawa. Wish you the best. God bless you all. Okay. 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 Karibuni sana. Okay.